So loud. Oh, scared the crap out of me. Three sodas on it.
Don't talk, man. I'm saying don't get baited because they're gonna ask you questions and nothing you say is gonna change their mind.
I know.
So I would just deny everything.
Good morning, everyone. This is Kristen O'Neill with the Committee on Open Government.
I'm
Welcome to our program this morning regarding the New York State Freedom of Information Law. If you have questions as our presentation goes along, as you see something that comes up during the presentation that you have questions, you're welcome to put them in the chat feature. I'm not going to be responding to chat questions as we go along. I will wait until the end of the program and respond to all questions at that point. This program will be recorded, is being recorded, and will be posted on the website of the Committee on Open Government within the next week or so. Sometimes it takes a little bit. Well, let me just say, I think we've got some people that are unmuted, so I just want to unmute all. All right. Okay, I think we're set now. Just some heard some background noises, so I was thinking that perhaps we had some unmuted attendees. Sorry about that. So the program will be recorded, will be posted on the website of the Committee on Open Government within the next week or so. So that's opengovernment.ny.gov. I get it recorded, then I have to, download it and send it to our IT staff. So sometimes it takes a little bit, but hopefully by no later than the end of next week, should I have it up on our website. If you go to opengovernment.ny.gov, there's a specific section of our website that says view recording, training materials and recording. Copies of the PowerPoint that you see right now is available in PDF format on our website, and recordings are available on the website. So we'll get started. Up on the screen right now is my name, title, telephone number for the Office of the Committee on Open Government. If you call, you're welcome to ask to speak to any of the attorneys in the office. I do ask that you don't ask very factually specific questions in this program, like ones relating to your specific requests. If you have those types of questions, please submit them at the end of, submit them to me directly or to the Committee on Open Government directly. This is more about me trying to provide a broad overview of the Freedom of Information Law and giving everybody a basic understanding of rights and responsibilities. Right now, we are a little bit short-staffed. We have one of our attorneys is happily out on family leave, so that's nice, wonderful for her. But we are a little bit short-staffed, so forgive us if it takes slightly longer than normal to get back to you. So because we're just down a little bit. But if you send an email to our office, which is coog, COOG at dos.ny.gov. That's our general email address. There's contact information available on our website, and that's our telephone number that you see right there. New York State Freedom of Information Law is codified in New York State Public Officers Law, Article 6. And you'll find a copy of the Freedom of Information Law on our website on the opengovernment.ny.gov. Whenever we are notified of an update, an amendment to the law, to either the Freedom of Information Law or the Open Meetings Law, we make sure that we update the version that's on our website accordingly. So we do make every effort to make sure that the version that you're seeing on our website is the most up-to-date version of the statute. In addition, just a quick, shout out to our website. If you are looking for information regarding the Freedom of Information Law or the Open Meetings Law, it's really a great place to start. It's a good resource. We have a publication called Your Right to Know, which gives a nice overview of both of the statutes. We have copies of the statutes, the FOIL regulations, advisory opinions, case law summaries, copies of our past annual reports. Whenever there's any updates or changes to the law, we try to highlight that right on our homepage of our website when we're offering programs such as these virtual programs that gets posted on our website. So it's a good website to keep an eye on. This is what it looks like. This is just sort of a hey, this is what the Committee on Open Government's website looks like, in case you're wondering. The Freedom of Information Law, we're going on its 50th birthday. The original law was enacted in 1974, but it was fairly limited in scope. It gave access to 9 categories of records. The type of record that you were seeking was not included in that 9 categories of records. You were somewhat out of luck, and it wasn't a very popular version of the statute, and it was repealed and replaced with the current version, which is based on a presumption of access. That occurred in 1978. So what do I mean by presumption of access? Often the Committee on Open Governments gets questions such as, is this a FOILable record, or is this a public record? And from the standpoint of a government agency and from the public, everyone should always assume that all records maintained by a government agency are available under the Freedom of Information Law. You start with the assumption that all of those records are public and subject to FOIL disclosure, unless the agency can assert one of the permissible statutory grounds for denial. Who is covered by FOIL? FOIL governs access to agency records, and the term agency is defined in statute as any state or municipal department, board, bureau, division, commission, committee, public authority, public corporation, council, office, or other governmental entity performing a governmental or proprietary function for the state or for any one or more municipalities thereof. This is pretty broad definition. Any entity that you think of as a governmental entity is probably an agency subject to FOIL. You've got all the agencies at the executive level under the governor's office. For example, the Department of Health, the Department of State, Department of Labor, all of those entities are government agencies that are subject to and are required to comply with the Freedom of Information Law. You sort of work your way down through county government, cities, towns, villages, school districts, fire districts, water districts, libraries, public libraries. All of those entities are agencies that are required to comply with the Freedom of Information Law. What is not an agency that is subject to FOIL? The judiciary and the state legislature. So the courts, you cannot make a Freedom of Information Law request to the courts for court records, for records maintained by the courts. Rights of access to those records is governed by separate statutes, specifically judiciary law. So courts are not required to respond to a Freedom of Information Law request. And it's not to say that those records aren't generally public. It's just that FOIL is not the mechanism for obtaining those records. The state legislature is also not an agency, as that term is defined by the Freedom of Information Law. The state legislature does have obligations under FOIL, but it's much more limited in scope. It's actually very similar to that original 1974 version of the statute, where here's a list of the types of records you can obtain from the New York State Legislature. If you don't see it on that list, you're sort of out of luck. Every agency that is subject to FOIL is required by law to appoint a records access officer. And who is the records access officer? So the governing body of the agency, or the governing body or the head of the agency, is responsible for ensuring compliance with law and regulation, and shall designate one or more persons as records access officer by name or by specific job title. This designation must include a business address and an email address. And that person, who's the records access officer, has the duty of coordinating the agency's response to public requests for access to records. So as you can see, the entire agency has a legal responsibility for complying with the Freedom of Information Law. The records access officer is not the only person within the agency that has responsibilities relating to FOIL. Just simply that the records access officer is designated as the point person, so to speak, the person that receives the Freedom of Information Law request and then starts the ball rolling in terms of gathering those records, pulling them together, and then reviewing them to determine rights of access. What is a record subject to the Freedom of Information Law? The term record under FOIL is incredibly broad. It means any information kept, held, filed, produced, or reproduced by, with, or for an agency in any physical form whatsoever. And then the statute includes a list, a non-exhaustive list of examples, but it's any information in any physical form. And if you can sort of see it, read it, hold it, touch it, or see it on a computer screen, it's a record subject to FOIL. The Freedom of Information Law does not obligate an agency to create records, to create new records in response to a Freedom of Information Law request. The law does not obligate an agency to answer questions. The law simply requires that an agency provide access to existing records maintained by that agency consistent with the statute. So this does not mean that an agency is not required to make copies of records or to convert those records to a preferred format if possible. It simply means that you're not obligated as an agency to manually prepare a new record or to provide explanations in writing where those explanations did not exist prior to the FOIL request. As with most rules, there are exceptions. Under the Freedom of Information Law, there are 3 records that every agency is required to create and maintain. The one is that every agency that houses a public body, so for example, if you're a town government and you have a town board, that town as the agency is required to maintain a record of how each member of the public body, in other words, for example, the town board, votes in any given proceeding or matter. So you go to a meeting of a town board and there the town board votes on several issues during that meeting. The Freedom of Information Law requires that the town maintain a record of how each member of that public body voted on any given matter. The second exception is that every agency is required to maintain and make available a list of the name, public office address, title, and salary of all of its employees and officials. So to clarify there, it's public office address, not home address. Home addresses of public employees and officials are not required to be disclosed. This is simply, for example, I work in the Albany offices of the New York State Department of State. So the record would reflect my name, my title, the fact that I work at 99 Washington Avenue, Albany, New York, my title, my salary. That's what that record needs to include. The third exception is every agency is required to maintain and make available a reasonably detailed subject matter list of the records that that agency maintains. Many local governments adopt the record retention and disposition schedule established by the New York State Archives as their subject matter list. And this is perfectly acceptable. They line up pretty nicely. It's called the schedule that's established by the New York State Archives for local governments and school districts is called the LGS-1. So if a local government adopts the LGS-1 as their reasonably detailed subject matter list, in our opinion, that would be compliant with the law. So I was going to focus a little bit more on that distinction between creating new records and preparing copies of existing records. The law states that an agency shall provide records on the medium requested by a person if the agency can reasonably make such copy or have the copy made by engaging in outside professional service. So try to use simple examples because that's the way my mind likes to work. Let's say, for example, that an agency maintains records in the only format that they currently have those records in is paper. They're sitting in a filing cabinet somewhere in paper format. And the person who's making the request would like an electronic copy of those records emailed to them. If the agency has the ability to scan those records just as easily as they would photocopy those records and have the ability to attach that electronic copy of a record to an email, they would be obligated to do that. So the agency, if the person wants an electronic copy of the record and the agency has the ability to make an electronic copy of that record, then that's what the agency should be providing. Another distinction here is when an agency has the ability to retrieve or extract a record or data maintained in a computer storage system with reasonable effort, it shall be required to do so. So sometimes an agency may think, well, this person who's making the request is requesting a report that we don't prepare in the normal course of business. It's not one I don't have a PDF, I don't have an Excel file in my on my computer that contains this information. And the agency is under the impression that querying the database and preparing an Excel file, for example, that they've never prepared before is considered preparing a new record. But the legislature addressed this and clarified that extracting data from a database, it's existing data that's maintained in a database, and producing that record in an accessible format, transferring the record to a medium requested by the person, shall not be deemed to be the preparation or creation of a new record. So if an agency has the ability to query the database and produce a record that is responsive to the request, it is obligated to do so. It's the responsibility of the person who's making the Freedom of Information Law request. The person who makes the request, first, if the agency requires it, the applicant would be required to put the request in writing and to reasonably describe the record sought. What does this mean? Part of it is just common sense. Does the agency understand what's being requested? Or has the applicant included enough detail to allow the agency to locate the record with reasonable effort? For example, if you're talking about a copy of a building permit, has the applicant provided a street address or lot number that would allow the municipality to locate that building permit? So part of it has to do with just providing enough detail or using terminology that the agency is familiar with. Have they reasonably described the record sought? Part of the issue is whether the agency maintains their records in a manner that would allow them to locate the specific record sought with a reasonable effort. So the agency may receive a request and they may know that they possess the record somewhere, but the person who's making the request has not provided the elements that would allow the agency to locate the record with reasonable effort. I'll give you an example here. Years ago, the Committee on Open Government was much more, let's say 10, 15 years ago, it's much more paper oriented. We had an administration that really liked paper, and almost everything we received was printed and stored in filing cabinets. And some of you may be aware that every time an individual files a FOIL appeal and an agency issues a FOIL appeal determination, they're required to provide copies of the appeal and the appeal determination to the Committee on Open Government. So what would happen is, to a large extent, again, 10, 15, 20 years ago, we would receive those records in paper. Every day we would open our mail and we would review those appeals that we received, and then they would get filed based on date received. They would just honestly they weren't logged, they were simply placed in a filing cabinet. The picture that you see up on the screen is sort of an accurate representation of what the filing cabinet looked like. They would just get placed in a filing cabinet based on the date they were received. So if someone had made a Freedom of Information Law request for copies of all appeal determinations that have been issued, for example, by the City of Albany, we would have had a very difficult time complying with that request because we didn't have a database that reflected if and when we received any appeal determinations from the City of Albany. And so unless someone provided us with an approximate date of when such appeals would have been issued, we really had it would have required more than a reasonable effort for our staff to go through the thousands of appeal determinations that we receive annually to locate the ones that had been issued by the City of Albany. Now, fast forward to 2023, we're a little bit better about keeping electronic records. When we still get paper, people still send us paper, but some of the appeals that we receive are sent via email or sent via paper. But regardless, we track them. Sorry. We have an Excel file that basically tracks the appeals that we receive. So we know the date that the appeal was received. We know who the appellant was. We know who the agency was that issued the appeal or issued the appeal determination. So if someone came to us and asked that same question, requesting copies of appeal determinations issued by the City of Albany over the past year, it would be much easier for us to locate those records. We would simply go to our Excel file, do a search for the City of Albany, and then be able to pluck those records because now we would know when we received those appeals. Time limits. Freedom of Information law contains time limits that establish when and how an agency is supposed to respond to a request. The first time limit that comes into play is 5 business days. Within 5 business days of receiving a Freedom of Information law request, an agency has to do something. That might be responding to the request, particularly if it's a fairly simple, straightforward request for records that are easily accessible and clearly public. An agency may very well turn around and provide access to that record within the first 5 business days. A second option may be that the agency receives the request and sees that the records that are being requested are, there's an exception to the rights of access that cover that record, and it's a fairly simple review. Maybe it's just a one piece of paper, but they know that that one piece of paper, there's an exception that can be applied that would allow them to withhold that record. So a denying access to a record may also occur within that first 5 business days. A third option might be that the agency responds to the applicant by advising that the agency does not possess the record sought. Perhaps the applicant submitted a request to one municipality when in fact it should have submitted it to a different municipality. Or perhaps the applicant submitted a request for a record that is 30 years old and the agency no longer possesses it because the record retention period has expired. So that's another way that an agency may respond within that first 5 business days. The fourth option comes into play when you're dealing with numerous FOIL requests, voluminous FOIL requests, slightly more complicated FOIL requests. When an agency sort of has a higher level of a FOIL load, much more frequently what they're going to need to do is acknowledge the request within the first 5 business days. And then within that acknowledgement, they should be providing a date, an approximate date by which they plan to respond. If the agency is unable to respond within 20 business days of the date of that acknowledgement, so if they say they can respond within 20 business days, that's the approximate date that they should be providing in that acknowledgement letter. If the agency does not believe they can respond within 20 business days, what they're required to do is provide a date certain by which they plan to respond that is reasonable given the circumstances of the request and of the other FOIL workload. In addition to providing that date certain at the time of the 5 business days, the agency may also indicate at the time of the acknowledgement, they may indicate that they hope to respond within 20 business days, but at some point prior to that expiration of that 20 business days, the agency is going to advise the applicant that they need more time, and they get that one more bite at the apple prior to the expiration of the 20 business days. They, at that point, provide the date certain by which they plan to respond that is reasonable under the circumstances. Committee on Open Government has long offered the opinion that the law does not contemplate repeated extensions. For example, some agencies send out extension letters month after month after month after month. It's our opinion that that is not permitted under the statute. The courts don't always agree with us. The courts tend to look a little bit more broadly to determine whether the time taken by the agency is reasonable. I'm going to give you my little plug here for why, if you're a government agency, why it's not a good idea to issue those repeated extensions and why it's a better idea to fully evaluate the request right from the start and make sure you're providing a date certain as early as possible to the applicant so they understand the volume and complexity of the request and how long it's going to take. If you tell an applicant that it's going to take 6 months to respond or even a year to respond, given the volume and complexity of the request, the applicant may very well be willing to narrow the scope of the request. So by giving some serious thought to how long it's going to take right from the start to respond to this request, the agency is acting in everyone's best interest. It gives the applicants a clear understanding of how long they're going to have to wait instead of keep getting pushed out every month, which is very frustrating. The applicant has no clear expectation of when they're going to get the records. That's very frustrating for the applicants. We see this, we get complaints about this all the time. It's probably our most frequent complaint that the Committee on Open Government receives is that government agencies take too long to respond to FOIL requests. I would say that is most likely we don't really track the numbers, but anecdotally, that's in my mind since I've been working here for 8 years. That I would say anecdotally is our most frequent complaint, is that agencies take too long to respond to FOIL requests and that they're not upfront about how long it's going to take. So if agencies are upfront about how long it's going to take to respond to the request, it may be in their best interest as well, because the applicant may decide that they can narrow the scope of their request and focus on the records that are of most importance to them, important to them. If there's a denial of access, the applicant has 30 calendar days to appeal the denial. If once the agency receives an appeal, the agency has 10 business days to respond to the appeal. Someone just asked me yesterday if I knew why almost everything is in business days except for the time to appeal, and my answer was no, I don't know the answer to that. I think it's been the statutory language since the law was passed. So I'm not really sure what the thought process was, why everything is in business days except for the time to appeal. But that is something to keep in mind if you are a FOIL applicant, is that it is calendar days. You want to make sure that you're appealing within 30 calendar days. Email requests. All agencies must accept requests via email. The statute says if they are able to, but let's face it, in 2023, there is no reason why any government agency does not have the ability to accept FOIL requests via email. An agency cannot require that a requester use its own form. And from our perspective, this includes electronic forms and portals. An agency can require that the request be made in writing, but if the applicant would prefer to simply submit a request via US mail or via email without using the agency's electronic forms or portals, or even written forms that an agency makes available, they must be permitted to do so. Part of the problem with the electronic forms and portals that many agencies use is that in order to submit a request, the portal has many more mandatory fields. It requires much more information than the agency is entitled to. There's nothing wrong with asking for the information, but the agency isn't entitled to that information. So if the person doesn't want to use the agency's portal because they feel that the portal is asking for more information than the agency is entitled to, they should be permitted to submit a request in some other format. Simply, like, for example, by submitting an email request to the agency's records access officer. Unless there are personal privacy concerns, an applicant for records should be permitted to remain anonymous. So for example, if someone is requesting a record that is clearly public, contracts, meeting minutes, things of that nature, and they submit a FOIL request from johndoe@gmail.com and ask for you to provide that record electronically, you're required to respond. As an agency, the agency is required to respond to that request. Appeals. There are two circumstances that give rise to the right to file an administrative appeal. The first is an express denial of access or an affirmative denial of access, and that's where the record is possessed by the agency, but the agency has advised that it is withholding it in whole or in part. Under those circumstances, the agency is required to put the reason for the denial in writing and provide the applicant with instructions for how to file an administrative appeal and to whom that appeal should be directed. The second situation that gives rise to the right to file an appeal is a constructive denial of access. And that's where the agency fails to respond to the request within the time limit set forth in the statute. So someone submits a FOIL request and the agency fails to even acknowledge it within 5 business days. Or perhaps they acknowledge it within 5 business days and advise that they will respond on or before July 12th, 2023, and July 12th, 2023 comes and goes, and the agency has failed to respond by its own self-imposed deadline. If that's the case, the applicant has entitled by statute to treat that as a constructive denial of access and to file an administrative appeal. The Committee on Open Government has model appeal language on our website. So if you are an applicant for records and you are attempting to file either a regular appeal of an affirmative denial of access or an appeal of a constructive denial of access, we do have model language for both of those types of appeals on our website. So here's a lot of information that you're going to see up on the screen covering. Keep in mind, as I mentioned, I know a lot of people joined a little bit late, so I'll reiterate that these PowerPoints that you see are available on our website. We have a section, if you go to the homepage of the Committee on Open Government's website, which is opengovernment.ny.gov, and you go to the section, scroll down a little bit, you're going to see a section, I would like to view training materials and recordings. That's going to bring to you to PDF copies of my FOIL and open meetings law presentations, as well as a link to our YouTube page that includes recordings of past virtual remote programs. So for those of you that joined late, just want to reiterate that for you. Don't feel like you have to take notes or take pictures. All of this information is available on our website. So we're going to talk about some of the permissible grounds for denial. I'm going to go over some of the more frequently asserted grounds for denial. And again, keep in mind, presumption of access, all government records are public unless you can assert one of these grounds for denial as an agency. The first ground for denial of access is the only ground for denial that is mandatory. The rest of the statutory grounds for denial are permissive, meaning an agency can assert them, but is not required to. However, if a record is exempt from disclosure by state or federal statute, the agency is required to comply with that state or federal statute. It may very well be prohibited from disclosing those records. So some examples here are attorney-client communications that are made confidential pursuant to New York State civil procedure, civil practice law and rules. So if you have a municipal government and you have a town attorney providing legal advice in writing to the town board, for example, that's a communication that would be covered by the attorney-client privilege, and that is confidential. Access to those records is governed by a separate statute, and access to those records are exempt from FOIL disclosure by state statute. A federal statute, the Family Educational Rights and Privacy Act, makes all student education records confidential. So if you make a FOIL request to a local school district, a community college, CUNY or SUNY, any public institution that normally is subject to the Freedom of Information Law, access to student education records is governed by a separate statute. Access to those records is not governed by the Freedom of Information Law, and an agency is prohibited. For example, if I tried to obtain copies of my neighbor's kids' education records, clearly the school district would be prohibited from disclosing those records to me because I am not a qualified individual to receive those records. In my previous life, I was the records access officer for the New York State Office of Mental Health. Somewhat frequently, we would receive Freedom of Information Law requests for psychiatric records. Obviously, those records are confidential by both state and federal law. New York State mental hygiene law makes those records confidential. So even if you are an individual who received mental health treatment and you are attempting to obtain copies of your psychiatric records where you received treatment at one of our public institutions, the Freedom of Information Law would not be the appropriate mechanism for obtaining those records, even if those records are about yourself. You would submit a request to the records department of the facility, and access to those records would be governed by New York State mental hygiene law. Excuse me. In addition, the HIPAA privacy regulations would prohibit disclosure of those records as well. Some lesser known examples are autopsy records. So if you make a Freedom of Information Law request to a county coroner or medical examiner, autopsy records are confidential under New York State county law, and the county should not be disclosing those records in response to a Freedom of Information Law request. The same is true for county operated E911 records. Any records of E911 calls, including recordings and transcripts of those calls, access to those records is not governed by the Freedom of Information Law, but instead is governed by New York State county law. Social Security numbers are made confidential pursuant to Public Officers Law, Section 96A. So if an agency maintains records that contain an individual's Social Security numbers, the agency should always be sure they are redacting the Social Security number prior to disclosing the record. All right, so that's the must withhold. The rest of the examples that we're going to provide are may withholds. Unwarranted invasion of personal privacy, which can be somewhat subjective, of course. When an agency maintains certain types of records, either the record in its entirety or portions of those records could be withheld on the ground that disclosure would constitute an unwarranted invasion of personal privacy. Some examples there. Employment applications of individuals that applied for a job were not hired for a public position. So you had an opening in a government agency and 10 people applied for that position, but only one individual was hired. The employment history, the identity of the individual who applied for the position but was not hired, and any details that would tend to identify that individual can be withheld. Home telephone numbers, personal cell phone numbers of both the public and public employees can be withheld. Any medical information. Of course, if it's medical information maintained by a healthcare provider, that's a must withhold. But I'm talking more of examples of maybe you have medical information about your employees as a government agency. Their personnel file maybe contains information about Family Medical Leave Act or workers' compensation, things of that nature. So if there's information relating to one of your employees' medical information, that could be withheld on the ground that disclosure would constitute an unwarranted invasion of personal privacy. Public employees' home addresses can be withheld. Lists of names and addresses of natural persons, if that information could be used for solicitation or fundraising purposes. That's another example where disclosure could constitute an unwarranted invasion of personal privacy. I'm going to reiterate here, sometimes I get government agencies who are under the impression that they can withhold any information if that information is going to be used for solicitation or fundraising purposes. So here I'll just remind those agencies that this is very limited. It's names and addresses, and this could include mailing addresses or email addresses, but it's names and addresses of natural persons if that information could be used for solicitation or fundraising purposes. Example, at town government, you've got a list of individuals that applied for dog licenses, and somebody comes in and makes a Freedom of Information Law request for the names and addresses of all the individuals that received dog licenses. The agency can require that the person who's making the request complete a certification that that information will not be used for solicitation or fundraising purposes and will not be shared with anyone else who will use the information for solicitation or fundraising purposes. If the person making the request refuses to provide that certification, maybe because they know that, well, that's why I was making the request in the first place. I run a dog grooming company, and that's exactly why I wanted the information. So if they're not able to complete the certification, then the request can be denied on personal privacy grounds. Fairly recent amendment to the statute is mugshots. A copy of an individual's mugshot can be withheld on the ground that disclosure would constitute an unwarranted invasion of personal privacy. And as a side note, public employees enjoy a lesser degree of privacy than others. There's lots of information about public employees that would be available, that would not be available about somebody who works in for a private corporation. Law enforcement. There is a ground for denial of access for records when the records have been compiled for law enforcement and disclosure of the records would cause some type of harm. So it's a two-part test, and the agency has to be able to meet both parts of the test in order to withhold a record. The first part is that the record is compiled for law enforcement purposes. And in determining whether the record has been compiled for law enforcement purposes, the agency is going to look to see what the records are being used for at the time of the request, not what they were originally created for, but what they're being used for at the time of the request. And this became an issue about 6 years ago. There was a Department of Justice investigation relating to an employee who worked for the New York State Executive Chamber. And the New York Times made a Freedom of Information Law request for that individual's timesheets, their time and attendance records. Of course, you wouldn't think time and attendance records would be records that were compiled for law enforcement purposes. But at the time of the request, those records had been compiled and turned over to the United States Department of Justice because the Department of Justice had demanded them. So the fact that the executive chamber characterized those records as compiled for law enforcement purposes, the court upheld that determination, said, yes, that is an appropriate characterization because at the time that the FOIL request was made, that's what those records were being used for. Exemption does not only apply to criminal law enforcement, it also applies to civil law enforcement. There's a decision that came about relating to a civil law enforcement investigation being conducted by the New York State Education Department. And the courts held that, yes, that state agencies that have a civil law enforcement function can assert the compiled for law enforcement purposes ground for denial. So that's part one of the test. Part two of the test is that the agency that maintains the record has to be able to assert that some type of harm would be caused by disclosure. And then the law sets forth what types of harms can be asserted. One is that disclosure would interfere with a law enforcement investigation or judicial proceeding. If the agency that receives the request is not the agency that is conducting the investigation, the agency that receives the request has to consult with the agency that is conducting the investigation and determine whether disclosure would interfere with the investigation. So the entity that is conducting the investigation has to confirm that, yes, disclosure would interfere with the ongoing investigation. The second harm is that that disclosure would deprive a person of a right to a fair trial or impartial adjudication. Third is identify a confidential source or disclose confidential information relating to a criminal investigation. And here it specifically relates to a criminal investigation. And the fourth harm is reveal non-routine criminal investigative techniques or procedures. So this is the type of information. Let's say a law enforcement agency has a procedure manual To a large extent, that procedure manual would probably need to be disclosed if a FOIL request was made for it. However, if that procedure manual contained information which, if disclosed, would allow a potential criminal to evade law enforcement detection, then if that's the case, that would be a ground for redacting portions of that manual. Another frequently asserted ground for denial of access is the intra-agency and interagency material exception. And this ground for denial is intended to protect the deliberative process. It allows government agencies, either a single government agency or multiple government agencies, to communicate with each other and share their ideas, their advice, their recommendations, their opinions, without all of that information being needing to be disclosed. What is required to be disclosed, if contained in intra-agency is communications all within a single agency. Interagency are communications between or among multiple government agencies. What is required to be disclosed is if those records contain statistical or factual tabulations or data. The courts look at that as, is it objective information? What also is required to be disclosed is instructions to staff that affect the public. Final agency policies or determinations and external audits, including audits conducted by the Office of the State Comptroller. In terms of like policy manuals, those are policy manuals, guidance documents that are provided to government employees that set forth how they are supposed to be performing their jobs. Those are the types of records that would need to be disclosed. Sometimes when an applicant submits a FOIL request, the agency may respond by stating that it does not possess the record sought. And this is not a denial of access that gives rise to the right to an administrative appeal. So if as an applicant for records, the response you receive is that we do not possess a responsive record, that's not a denial of access. That is simply a statement that we don't have what you're looking for. If you have reason to question that response, your remedy is to request a certification from the agency. So this is a legal statement. It's a statement provided by the agency. And certainly it has legal bearing. A false certification could raise potential criminal liability on the part of the agency, but the agency would certify that it does not possess the record sought or that the record cannot be found after a diligent search. Another scenario that gives an applicant the right to request a certification is when they receive a copy of the record, or even maybe at the time that they make the request, they ask that the agency certify to the correctness of the record. This does not mean that the agency is required to certify that the content of the record is correct. It merely is required to certify that the copy that is being provided to the applicant is a true and correct copy of the original maintained by the agency, so that the copy essentially looks exactly like the original. Now, if there are redactions, you can certify that subject to the appropriate redactions, this is a true and correct copy of the original. But that's what a certification, when someone asks for a certified copy, FOIL doesn't require an agency to provide a certified copy in the traditional sense. Oftentimes when we hear the term certified copy, we think of something with like a seal attached. That's not what FOIL requires. FOIL merely requires that a representative of the agency who has knowledge either of the search that was conducted or that the copy that was provided is a true copy. Someone with knowledge of that fact should provide a certification that in writing that it's a true and correct copy, or that the agency does not possess the record. Right to appeal, we talked about some of this already, but when denied access to a record or any portion of a record, this means if one single word on a document is redacted, that is a denial of access, and the applicant has 30 calendar days to appeal that denial. So when there's a denial of access, the agency is required to provide a reason for the denial, and the agency is required to provide direction on how to file an appeal. So that denial letter should state that the applicant has 30 calendar days to appeal. It should state to whom that appeal should be directed, should provide name, title, address. By statute, the FOIL appeals officer is the head or governing body of the agency or the person or persons designated by the head or governing body. The FOIL appeals officer cannot be the same person as the records access officer. Within 10 business days, the FOIL appeals officer must either provide the records sought or fully explain the reasons for further denial, and sometimes it's a combination of both those things. The law does not contemplate a remand back to the records access officer. It is the responsibility of the appeals officer to review the records at the appeal level. And as a reminder, the agency is required to send a copy of the appeal and the appeal determination to COOG. Just as a shout out to all you agencies out there, I have to say that frequently we receive appeal determinations without the appeal. If that is your practice, please be reminded that in addition to providing us a copy of the appeal determination, you are required to provide us with a copy of the appeal as well. Fees. This is probably my number 2 thing that I talk about after time limits is fees. The Freedom of Information Law allows an agency to charge a fee, excuse me, just a second, to charge a fee for making copies of records. Agencies, there's a lot of cost that goes into perhaps responding to FOIL requests, and to a large extent, those costs are not reimbursable. There's time and energy that goes into gathering and reviewing records and determining rights of access, to searching for the records, locating the records, reviewing those records to determine rights of access. The time it takes to do all of that is not a reimbursable cost. The only fee that an agency is permitted to charge is the fee for actually making a copy of the record. If an agency is making photocopies, the agency is permitted to charge 25 cents per photocopy up to 9 by 14 inches. Agency cannot charge for the time it takes to make the photocopies, cannot charge for the search time, cannot charge for the time it takes to review the records to determine rights of access. When photocopies are being provided, it's 25 cents per photocopy. That's it. End of story. Done. The second fee structure, and again, please remember, there is, these 2 fee structures cannot be combined. It's one or the other, either providing photocopies or you're providing copies in some other format. If it's records larger than 9 by 14 inches, then you can charge the actual cost of reproduction. And this comes into play sometimes when you're dealing with maps and blueprints and things of that nature. Either it's the actual cost of the agency making the cost in that copy in-house, or it's the cost of sending it out to a third-party vendor to make the copy. The other situation that comes into play more frequently is when you're dealing with electronic records or records in some other format. So first, let's say you're dealing with the agency possesses records in paper, and the person who's making the request says, I don't want photocopies. I want you to scan the records and provide me with and then email those records to me. If we're talking about perhaps 50 to 100 pages of records, the likelihood is that the agency is not going to be able to charge for that, the cost of making those copies. Because say, for example, the agency has to scan those pieces of paper to make an electronic copy, the agency would only be permitted to charge the hourly salary of the lowest paid employee capable of scanning the records, but only if it takes at least 2 hours to scan the record. So if it only takes you 15, 20 minutes to scan a record, to scan 50 to 100 pieces of paper, no fee is going to be authorized. The same is going to be true for data extraction. Let's say, for example, you need IT staff to pull data from a database to prepare a report that's being requested. You would only be able to charge the time it takes to prepare that report, to make a copy of that report, if it takes at least 2 hours for agency staff to prepare that copy. If you can't send something via email and you need to put it on an electronic storage device like a CD or a thumb drive, you're allowed to charge the actual cost of the electronic storage device. Someone told me the other day that they'd been charging people $25 for a CD. Clearly, CDs don't cost $25 per. When you, as a municipality or a state government agency, purchase bulk CDs or DVDs, it's probably like 25 cents per CD. Whatever the cost to the agency is the cost that can be passed along to the applicant. So please do not be charging applicants $25 per CDs or DVDs or thumb drives. Some thumb drives may, of course, be a little bit more expensive, but they're certainly not $25 a pop. Again, I mentioned the third-party vendor. If you need to send something out to a third-party vendor, like if you have video or audio or maps or blueprints that you don't have the technology to make copies of in-house, and you need to send it out to the third party, whatever the third party charges you, you can charge the applicant. And again, reminder, you cannot charge for search or review time. An agency cannot charge for the time it takes to locate the records, to search for the records, or to review those records to determine rights of access. It is not a reimbursable cost. A fairly recent amendment to the Freedom of Information Law states that where an identical record has been prepared for a previous request within the past 6 months and an electronic copy is available, an agency shall not charge a fee for the reproduction of the record, except for the actual cost of a storage device or media if one is provided to the requester in complying with such request. To be honest, I'm not sure why this was necessary because it should be common sense. The record retention period under the New York State Archives Record Retention and Disposition Schedule is 6 months for FOIL requests, and it's for records provided in response to a FOIL request. So if you as a government agency have an electronic copy of a record consistent with your record retention period, there would clearly be no reason to have to prepare a new copy of that same record. And if there's no obligation to prepare a new copy of that same record, there would be no cost for reproduction. If you have a PDF file, if you have an Excel file, if you have whatever format it is and it already exists, then you don't need to make a copy. You're simply just, you don't need to make a copy in any way that takes any length of time. You may need to do a, on your computer top, hit copy file and then attach it to an email or an electronic storage device, but there would be no reason to make a new copy of that record that would take any length of time. Enforcement. Minneapolis Open Government does not have enforcement authority. Often we get letters or emails asking us to sort of force an agency to do something. Please get these records for me. Please tell this agency that they have to give me these records. Our agency does not have enforcement authority. Who does have enforcement authority? The courts. So the Committee on Open Government can provide advice and legal opinions, and if that assists an applicant or an agency, we're happy. That's what we're here for. Hopefully we can help the public and agencies come together to mutual understanding of what the law requires, and that's an ideal situation, but we do not have enforcement authority. Enforcement is through a Civil Practice Law and Rules Article 78 proceeding in state Supreme Court. If a petitioner substantially prevails, attorney's fees and other reasonable litigation costs can be awarded. They're mandatory on the part of the judge when the requester has substantially prevailed and the court finds that the agency had no reasonable basis for denying access. It is discretionary on the part of the judge when the requester has substantially prevailed and the agency failed to respond to a request or appeal within the statutory time frame. As a reminder, anyone is welcome to contact our office by phone or by email with questions, whether you're a government employee, members of the public, media representatives, come one, come all. We are here with any of your questions regarding the Freedom of Information Law, Open Meetings Law, or if you're a state agency, the Personal Privacy Protection Law. You can call the telephone number that you see on the screen, which is 518-474-2518, and ask to speak to one of the attorneys in the office. You can email us at coog, COOG, @dos.ny.gov, and one of the attorneys in the office will get back to you as quickly as possible. One more plug I have for you, even though this is a Freedom of Information Law program. Currently, we have a college intern doing some survey work for us. Some of you that are interested in open government may very well be aware that last year during the budget season, so in April of 2022, as part of the budget bill, there was an amendment to the open meetings law expanding in very limited circumstances a public body's ability to use video conferencing under extraordinary circumstances. We're trying to do a survey. We're required by law to prepare a report for the governor and the legislature regarding these video conferencing provisions. And we want to gather as much information as possible from anyone who's interested, whether you're a member of the public who has their own thoughts and experience with the use of video conference, if you're a government agency, public body, or if you're a media with your own experiences. If you're interested in participating in that survey, if you'd like to email or call the phone number and say, hey, I'd like someone to reach out to me. Her name is Elizabeth Baird, is our college intern. So if you'd like Elizabeth to contact you, and it would only take 5 or 10 minutes tops. It's not very lengthy, but we're just trying to get some feedback. If you email us and you really don't even want to talk on the phone, we're happy to email you a copy of the survey and you can just respond in writing. So we do appreciate anyone who is interested and willing in providing us some feedback regarding those extraordinary circumstances, video conferencing provisions. We really appreciate it. So at this point, I'm just going to open up the chat feature and go through any questions that came in while we were talking. It's as big as possible. So I'm going to stop sharing only because, let's see, it makes it easier for me to read the chat feature. Let's see, chat, I'm going to open it right up wide. Sorry, give me a second here. All right, so I'm going to go back to the beginning. Someone asks, we have received a FOIL request for inspection of a private property. We denied the request on the ground that it does not seek inspection of public records and the village cannot provide access to private property. The requester repeatedly submits the same request. We have to respond to each duplicate request. I'm not quite sure what's meant for inspection of private property, but of course the village is only obligated to provide access consistent with law with records that the village maintains. It's not required to go and obtain records from a private entity in order to respond to a FOIL request. But if the village does maintain records relating to a private property, clearly those are records subject to FOIL. However, if the issue really is that the village does not maintain the records, and the requester keeps submitting the request regardless of how many times the village says we don't have the records that you're asking for, ultimately what I tell villages or what I tell government agencies to do is when someone submits a repeat request for a record that you've already responded to, just refer them back to the previous response. You don't need to keep preparing a new response. Just say, please see response issued on such and such a date. That way they understand this has already been addressed. It just hopefully just shuts it down eventually. At a certain point, if even that doesn't stop them, you can always include a note saying we will no longer respond to repeat requests for the same record. Next question is it necessary to send out a communication to the requester certifying that the record does not exist, or can the agency simply send out a letter? Well, that's all a certification is. If someone requests a certification, it's merely a statement in writing that the agency does not possess the record sought, or that the record cannot be found after a diligent search. That's all a certification is. So I'm not sure what the distinction here is between send out a communication or a letter. I'm not sure what that distinction is, but all it is a statement in writing. It can even be in email. It doesn't have to be notarized. It doesn't have to be a legal document. It's just a statement in writing from a government employee who has knowledge of the search that the agency does not possess the record sought. If someone asks, can we refer them to the FOIL portal if they write us an email? And the answer is no. If an applicant has submitted an email to the agency's records access officer requesting records, they've done their job. They should not be forced to jump through any additional hoops. Once they've submitted the request in writing, they've done all they're required by law to do. They should not be told to submit a request via the portal. Next question is for autopsy and 911 records. The comment, I'm just trying to read. The comment says, for autopsy and 911 records, could not public interest be argued for FOIL for the sake of public interest, say an application by a journalist? Sure, you can make that argument, but it's not going to change the fact that there are statutes that are currently in place that state that disclosure of those records in response to a FOIL request is prohibited. It's just access to those records is not governed by FOIL. Access to those records is governed by the separate provisions of New York State county law. Someone asks, does the mental hygiene law also apply to police officers who detain and transport someone to the hospital? The answer, if you're talking about, like, for example, records maintained by a law enforcement agency relating to mental hygiene records, the answer is no. Mental hygiene law does not apply statutory confidentiality to those records. However, I think a very strong argument can be made that the identity of the individual who was the subject of the mental hygiene detention and transport could be withheld on the ground that disclosure would constitute an unwarranted invasion of personal privacy. So no, I don't think it's confidential by statute, but yes, I think there are certain aspects of, like, for example, that incident report or detention record that could be withheld to protect the individual's privacy. The next comment is, with regard to the interagency exemption, can I clarify which agencies are covered? Agencies all within New York State versus outside of New York, federal, etc. So that's a good question. It's just agency as the term is defined by the New York State Freedom of Information Law. So if you have a New York City government agency communicating with the New York State Department of State, that is interagency communication. A communication between a New York City agency or a New York State agency and a federal agency is not interagency communication, because the federal government is not an agency as that term is defined by the New York State Freedom of Information Law. So you can have communications between local and state government. You can have communications between multiple levels of local government, and all of those would be interagency communications, but communications with the federal government are not interagency. And communications between, like, for example, an executive level state agency such as the Department of State and the New York State Legislature are not interagency, because the New York State Legislature is not an agency as defined by the Freedom of Information Law. Someone asked, is there a maximum amount that an agency can charge? And the answer is no. What is required to be redacted during a FOIL request? If the person FOILing is not involved, do they have right to the information? And that is a very, very broad question, which I guess I would hope that we've addressed in the past hour. And if this person has follow-up questions, they're welcome to contact us directly, but that was a large section of what we discussed during the presentation. Someone asked can I please share a copy of the slide presentation or a link to where we can access it? And this is also something that I discussed during the presentation. Hopefully people heard me. Is that copies of my presentations are available on the Committee on Open Government's website. If you go to our website, there's a section on view training materials and recordings. So that's where you're going to be able to find the slide presentation. Someone asked me to comment on agencies that consistently delay producing files, even when those files are known to be easily and readily accessible. It's not really a question. If this person has a question, they're welcome to follow up. Can I speak to the specific timelines for processing a trade secret exemption? Because it's very specific to state agencies, I guess I'd rather have, if you have this question, look to section 89.5 of the Freedom of Information Law. That's where those timelines are included. It's set forth right in the statute, but it's very specific to state agencies. Comment on ages. People are asking me to comment on things, and I don't want to get into that here. This is not like an opportunity for me to like slap people on the list or to to be anti-agency. I just want to provide guidance about what the rights and responsibilities are on the statute. What is the remedy when an agency returns a newly created document rather than providing the timestamped document that was requested? I don't really know what the question relates to. You have a right to request a specific document. If the document that you're provided is not the document that you requested, then that's something you need to follow up with the agency. Someone asked, is a 911 call able to be foiled? We discussed that during the presentation as well. The next question is, how do you respond to a village that insists that you fill out their FOIL form repeatedly when you submit requests via email? We have advisory opinions on our website. I think it's under the section. The advisory opinions are indexed by key phrase. So if you go to Freedom of Information Law advisory opinions and there's a section called form, prescribed use of. Take advantage of those advisory opinions that specifically offer the opinion that an agency cannot require that you fill out their form. If you continue to have those difficulties, you're welcome to request an advisory opinion from our office, but generally it's just going to say the same thing that we've already said in our previous advisory opinions, just reminding them that your statutory obligation is simply to put your request in writing. You cannot be required to fill out their form. So I've come to the end of the questions that were submitted through the chat. I appreciate everyone taking the time to join me today. Ultimately, if you do have questions going forward regarding the Freedom of Information Law or one of the other open government statutes, you are always welcome to contact us by phone or by email. My recommendation is just to ask to speak to one of the attorneys in the office, because the attorney that is most quickly able to get back to you is the one that will get back to you. If you have a question specifically relating to something that I said during the program, feel free to follow up with me directly. But there are times sometimes when I'm traveling for my presentations that I won't be able to get back to you as quickly. So it's always good to just ask to speak to one of the attorneys in the office. Not that I don't love to hear from people, I do. I just don't want people to be waiting if I'm not available. Thank you very much, everybody, and I hope you have a great day.